opening arguments with former Solicitor General Neil Katyal, who wrote the special counsel rules that govern Mueller and is, of course, an MSNBC analyst. Good to see you.
Good to see you, and welcome back. We missed you.
Glad to be back. Neil, walk us through what is important about a potential contempt vote or proceeding here against a sitting attorney general.
So Chairman Nadler has said that there will be this vote on Wednesday, and the vote is occurring because of a very simple thing, which is Barr has said, I'm not going to turn over the Mueller report, and he hasn't even bothered to go to court to try and get the grand jury material lifted so that could be shared with members of Congress, unlike his predecessors in Watergate and the Lewinsky investigations. So Nadler is saying, look, if you don't turn this over, we're going to hold you in contempt. And you're right, Ari, he said something really significant today. He mentioned the I word. Now, Jerry Nadler is not one to use the impeachment word lightly. Indeed, for the last 2 years, he's been the guy urging restraint, saying we only do this if we really have to. But now I think that because of what Barr has been doing with respect to the report, he's even, it looks like, starting to think about the I word.
When you look at that, it's all a fight over getting the rest of what Mueller has. As you mentioned, the unredacted report, the grand jury evidence, and Congress has a separate and a wider role than simply what a criminal prosecutor looks at. Then we have former federal prosecutors, over 300 today, coming out and saying their view is that the Mueller report shows Mueller himself thought this would have been a charge for obstruction against anybody else if he were not the president. Your view of that letter?
I mean, it's hugely significant. I've never seen anything quite like it, to have 370 plus former federal prosecutors, which span Democrats and Republicans, including really prominent Republicans like Judge Martin, who is a legendary judge on the Southern District of New York, appointed by one of the two President Bushes, and had another position from the other President Bush, all of them saying, when we review this evidence, it's obstruction of justice, and if this were anyone else but a sitting president, this person would be labeled a felony and staring down and staring down the barrel of a federal indictment. That is really, I think, a remarkable thing, and it strikes at the heart of what Barr has done so corrosively. Because remember, Barr resolved in 48 hours what Mueller didn't resolve in 22 months, which was, has the president committed obstruction? And those of us who read the Mueller report when Barr finally allowed us to read the redacted portions weeks later after his summary of it, which wasn't a fair summary, we looked at it and we're like, wow, this is actually a really strong obstruction case. Ben Wittes wrote a fabulous piece in The Atlantic all about it, and there's lots of other analysis that you can see. And what you have in this letter is 370 prosecutors saying, yeah, we agree with Wittes. We agree the Mueller report shows the president is a felon.
And so when you look at that, I wonder about the fight going on outside of the courtroom. You, as our viewers have come to learn, have argued a lot of Supreme Court cases, and you care a lot about what the 9 are doing. But everyone understands well, this is the real world, and the world outside the courtroom can matter. How much of do you think the 300-plus folks there weighing in are doing so almost as a direct rebuke or reaction to what you just described, what Barr did? I mean, I wonder if whether we'd had a fair playing field from the start and everyone just dealt with the evidence, whether as many people would have felt the need to come out that way.
Exactly. I mean, the fact that these folks did so, and these are pretty reticent folks. I mean, there's some people on there who, will sign letters and so on, but there's a lot of people who I'm not aware of have taken any public positions before. But I think they did so here because of the gravity of the situation. Here you've got someone who who's our sitting president, who's committed acts that, if committed by anyone else, we would call a felon and put in jail. And I think that they felt like that was their duty. That's all they could do. And particularly in light of an attorney general who has blown past any notion of attorney general independence the way that his predecessors have. And so I think that's part of what's going on. It's about the Mueller report and Trump, but it's also about Barr.
You mentioned Ben Wittes, and he and others have also written about how in Barr, Donald Trump may have finally found the protector he wanted. Reading here from the Mueller report, the president would bring up other former attorneys general, such as Kennedy and Holder, giving his view, this is Trump's view, that they had, quote, protected their presidents. That is brought up as a negative piece of evidence, although not, as lawyers would say, not dispositive, but negative about Trump's worldview. How much does it concern you that at the very time we're getting Mueller's findings, we're also witnessing an attorney general who is increasingly looking like he was created in Donald Trump's image?
Absolutely. I think it's worrying me greatly. I mean, this attorney general is acting in unprecedented ways, and the idea that he could be compared to Kennedy or Holder is preposterous. I mean, this attorney general, from the summary of the Mueller report to his clearing of the president on obstruction in the teeth of so much evidence against it, is not acting like the attorney general of the United States. He's acting like the attorney general of Donald Trump. And look, Donald Trump has lawyers to deal with this. He has his personal legal team. He has the White House counsel, whose job it is to represent the presidency. But the one thing that isn't the case is that the attorney general acts as the president's lawyer. And we have long history about this. I mean, for example, when President Andrew Johnson was impeached in the 1860s, his attorney general, Henry Stanbury, actually resigned as attorney general because he wanted to defend the president. And so he went and became his lawyer in the impeachment trial. And then, notably, after Johnson beat the impeachment conviction by a single vote, Stanbury wanted to be attorney general again. The Senate didn't confirm him. And that's an attorney general who's acting up and up. This one is not.
Neil Katyal, a master of precedent. The night is not over, and yet I believe you may have the only Stanbury reference on all of the news across America tonight, and we learned so much from you. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.